Would you raise your right hand for me, please? You do solemnly swear that the testimony you're about to give in the cause now pending shall be the truth, the whole truth, and nothing but the truth?
Yes.
You may proceed.
Ma'am, what is Munchausen syndrome by proxy?
Do I need to answer?
Yes.
Can you repeat the question?
Yeah, it's pretty simple, really. What is Munchausen syndrome by proxy?
Okay. My baseline understanding is a syndrome in which a caretaker for a child or for another person, how would I describe it? Either provokes or in some way gathers information in regards to medical things or other ailments for some kind of benefit to the caretaker. I'm sorry.
I want to read this back to you, make sure that I got it right in your words. Munchausen syndrome by proxy, according to your training and understanding, is a circumstance where a caregiver for a child provokes or in some way gathers information for some sort of benefit to the caretaker. Did I get that right?
I have not been trained specifically in Munchausen by proxy.
I understand that, but my question really is, with the description that you just gave me, that I just recited to you, did I get it right, as far as you understand it?
Yes.
Now, the child in this case, he really did have a problem, right?
Yes, this child had some problems.
Medical problems.
Yes, the child was noted to have some medical problems.
How long have you been a dependency investigator?
I was a dependency investigator for approximately 3 or 4 years. I'm not
I mean,
exactly
as
sure.
of today, how long? Are you still a DI?
No,
Okay, what are you now?
I'm a supervising children's social worker.
That's an SCSW?
Yes.
When did you get promoted?
From recollection, I believe it was around September 2011.
As part of that promotion process, did you undergo any sort of examination?
I went through an interview process and provided documentation in regards to performance evaluations and things of that nature.
But you did go through a face-to-face interview process, right?
And yes, in the promotion.
Going backwards from September 2011, how long were you a DI?
I believe I started in 2007, September.
Okay, going back to your promotion in September 2011, you had one interview, correct?
For that position, yes.
At any point in time, did anybody, as you were going through this promotion process, bring up the fact that a civil rights complaint had been lodged against you?
No, I don't recall that.
Do you know whether or not there's been more than one civil rights complaint lodged against you?
Not that I'm aware of.
Who is it that you believe lodged a civil rights complaint against you?
Well, the only one that I know of is the one involving Ms. Duval.
Did you review any documents in preparation for your deposition here today?
Yes.
Did you bring them here with you?
Yes.
Have you ever been trained that as a social worker in making reports to the court, you have a duty to be truthful, honest, accurate, and complete?
Yes, we were informed of that.
Did you review any of the medical records that you attached to the jurisdiction disposition report that you filed with the juvenile court?
No.
No. Did you review the upfront assessment that you attached to your jurisdiction disposition report and filed with the juvenile court?
I skimmed through it. I didn't read it in its entirety.
Is it your understanding that the people who did the upfront assessment of Miss Duval found her to be suffering Munchausen syndrome by proxy?
My understanding is that they asked for further assessment for that.
Did you tell the court that an upfront assessment had been done of Miss Duval?
Yes, it does indicate that in my report.
And did you tell the court that pursuant to the upfront assessment, Miss Duval needed to be assessed for Munchausen syndrome by proxy?
I recommended that assessment.
Did you also tell the court that at this time the disorder may have been confused with a mother who is medically knowledgeable and well informed about her son's diagnosis of sensory integration disorder? Did you tell the court that?
Per the upfront assessment, I don't believe I did.
You didn't.
I don't believe I did.
Now, you've been trained, actually since day one in your employment, that your court reports are important, right?
Yes.
That they're official documents.
Yes.
That in drafting them and filling them out, you are to be truthful, honest, accurate, and complete, correct?
Correct.
And that when there are voluminous medical records, you are to summarize the content of those records, correct?
Yeah.
And
I'd
in
say
your
that.
summary of the content of those records, you are to also be truthful, honest, accurate, and complete, correct?
Correct.
That way the court has the whole picture, not just little snippets, right?
Correct.
And in your experience, are your reports usually accepted into evidence?
I would say yes.
Okay. Is it your understanding, based on your training, that you act as the neutral eyes and ears of the court?
I would say that my role is to be neutral in making an assessment for a jurisdiction disposition report.
Right, neutral and objective, right?
Yes.
You've had that in your training, right? That you're not an advocate, you're to maintain objectivity, professionalism, and neutrality, correct?
In reports?
Yes.
Yes.
Now, as a dependency investigator, that's what we call a DI, right?
Yes.
What are your duties as a DI once the court has made the prima facie finding at the detention hearing?
Some of the duties would include interviewing parties, collecting documentation, assessing, doing client evaluations, and completing reports for the court.
Okay, let me make sure I got this. Your duties as a dependency investigator once the prima facie findings have been made at the detention hearing include interviewing parties, collecting documents, doing client evaluations, and completing the report for the court. Did I get that right?
Those are some of the duties, correct?
Okay, are there other duties that come to mind?
Well, completing the social study, which is part of the report, making recommendations.
That's also part of the report, right?
Yeah, those are the things that I can think of right now.
So going back to what your duties were as a DI, we have interviewing parties and third-party witnesses, and then collecting documents. What are we talking about when we're talking about collecting documents?
Medical records, police reports, things like that.
Do you have any training in reading medical records?
Not really. We have public health nurses that assist with that.
And when you have a public health nurse that you need to consult to review medical records and tell you what's in them, do you record that somewhere?
In some situations, or most of the time, when the continuing services worker gets medical records, or if there's medical records that come in, they go to the PHN and they enter them in the computer system.
Okay, what I'm trying to find out is you go out as a dependency investigator and you talk to people, right? That's your job.
Yes,
Okay. Then you gather up information, right? That's your job.
yes.
Is there a policy somewhere that directs you that all of your, the substance of all of your contacts is to be entered into the contact notes in the CWS CMS system?
I would say yes.
There is a policy that mandates that, correct?
That indicates that contact should be in the contact notes.
And in fact, it's more than that they should be in the contact notes. The training you get on that very subject is if it's not in the contact notes, it didn't happen, correct?
If it's not documented, it didn't happen.
If I want to look for all of the contacts that happen in the case, everything, where do I look?
If you're looking for all of the contacts, you're going to look in the delivered service log.
And they should all be there.
All of the contacts, yes.
Okay. And the reason we can trust that they are all there is because you've been trained. In fact, all the social workers that do any sort of service provision to the clients, whether it's emergency response workers, dependency investigators, continuing service workers, they've all been trained that you put all your contacts in the contact notes, right? In the delivered service logs.
I can't speak for every single person's training.
Is one of the reasons that you teach your subordinates, those 8 social workers that work under your command, is one of the reasons that you teach them to be truthful, honest, accurate, and complete in their reporting in the delivered service logs, because other people may look at it later and rely on that information. Is that one of the reasons you teach them to be truthful, honest, and accurate?
Yeah.
Yeah? Okay. Do you also teach your subordinate social workers, those 8 people that you manage today, do you teach them that all of their contacts should be noted in the delivered service logs? Because if it's not noted there, we question whether or not it even happened. Do you teach your people that?
I teach them to enter all of their contacts in the computer so that we have access to that information.
Okay, am I correct, ma'am, that as part of your job duties as a dependency investigator, you are to conduct a thorough investigation, right?
Yes.
Are you familiar with Los Angeles County Department of Children and Family Services Procedure Guide number 0300-503.10?
What is the title of it?
Writing the Jurisdictional Dispositional Hearing Report.
I've read it.
Okay, let me make sure I got this right, because it looks like we have 2 different terms at play here. By thorough, that would be the different aspects or allegations of the petition, right? So we want to thoroughly investigate the allegations of the petition, right?
Yeah, that's the jurisdiction part of the report.
Okay, and then independent, we want to independently investigate those allegations. What does that mean?
Evaluating each of the allegations in their own right, as well as not investigating based solely on the investigation of someone else, kind of like a new investigation.
So essentially, if I'm not getting this right, correct me. What the DI is supposed to do once they pick up the case is look at all of the allegations.
Mm-hmm.
Yes.
Yes.
And then go out themselves and investigate. That is, talk to the witnesses, look at the documents, gather the documents, that sort of thing, right?
I wouldn't necessarily say go out to re-interview all of the parties. Yes, the parents, the children, any collaterals with updated information, those people are interviewed.
I'm sorry, say it again?
Collaterals, parents, or things like that, those people are re-interviewed by the dependency investigator if there's updated information from the collaterals.
Okay, so collaterals and related witnesses would be independently interviewed by the DI?
They could be, yes.
They could be, or they're required to be under policy?
Well, if they're no longer involved with the case or they no longer have any updated information, there wouldn't be a need to interview them again if they're not involved in the...
I'm going to show you what will mark as exhibit number 1 to your deposition. Do you recognize exhibit number 1?
Yes.
Okay, what is exhibit number 1?
It's a procedural guide for writing the jurisdiction dispositional hearing report.
Okay, I'd like you to look down at the bottom of page 1 of exhibit number 1, where it says, after the arraignment/detention hearing, the department shall, it uses the word shall, right?
Yes.
Doesn't shall, ma'am, according to your training, education, you have a BA and an MSW, and your training with the County of Los Angeles, doesn't the word shall mean something's mandatory?
Sure.
So I'm correct on that? Means it's mandatory.
Sure.
Yes?
Yes.
Okay. The department shall conduct a thorough investigation. That means complete, doesn't it?
Okay. Yes.
Am I correct?
Yes.
Okay. So shall conduct a complete investigation, right?
Yes.
What does the word exculpatory mean according to your training?
I don't recall off the top of my head what it means according to the training.
Take a stab at it. What do you think it means?
Information that would, I guess, exonerate or find no wrongdoing.
Exonerate. So exculpatory information would be information that would exonerate the opposing side, right?
And that's my stab at it.
Do you recall being trained that you have an affirmative duty to disclose exculpatory evidence in your court reports? Have you been taught that?
I would say yes.
Okay. Because you want to tell the judge the whole story, not just bits and pieces of it, right?
Yes.
Have you ever been trained that if you omit material facts from a statement that you make to the court, that may render the statement false? Have you ever been taught that?
I will say yes.
Okay. And that's one of the reasons why, according to your training, when we're doing a court report, we want to be truthful, honest, accurate, and complete. We don't want to leave out important information, right?
No, we don't want to leave out important information.
Okay, because if we did and only gave part of the story, that would be the same as giving a false story according to your training, right?
I would say it's an inaccurate story if it's not a complete story.
Right.
Yes.
And again, I agree with you. I read a lot of your training. And one of the reasons that we want to give a complete story to the court is that in these juvenile dependency proceedings, the court is making very important decisions about families, right?
Yes.
The court is deciding, based on what you're telling them in those court reports, where a child will go, for example, right?
That's one of the decisions they can make, yes.
Whether the child will go home with its mother or go home with its father, as an example, right?
That's one example.
Whether the child will, or rather the mother, will only get monitored visits for the rest of that child's childhood or something more, right?
Our court can make recommendations, can make orders in regards to how we supervise the case while we have jurisdiction. But I wouldn't necessarily say it's for the rest of their childhood if we don't have jurisdiction the rest of their childhood.
Do you have any understanding about what happens when a court dismisses a case with exit orders?
It exits with specific orders in regards to custody and visitation, and then from there it is sent over to family law court.
Do you have any understanding as to the weight that the family law court is required to give to juvenile court orders based on your training?
I can't answer as to the weight that family law court applies to.
Have you ever been trained that the family law court will abide by the juvenile dependency court's exit orders unless there is a manifest change in circumstances? Have you ever been trained that?
I can't say that I've been trained in what family law court will do.
Now, as a DI, another one of your responsibilities is to draft the jurisdiction report, correct?
Jurisdiction dispositional report, yes.
Yeah, and that's usually combined into one report, right?
Yes,
And in that report, you're supposed to tell the judge the outcome of your independent investigation,
yes,
and you're supposed to present it in an objective, disinterested way, correct?
I would say perhaps, yes.
What do you mean by perhaps?
I'm not 100% sure if that's the exact language of how it's supposed to be done.
Have you been trained to avoid seeming biased?
Yes,
Have you been trained to let the facts speak for you in your reports?
yes,
Okay. And we've already covered this, but you've also been trained that your report must be based on your independent investigation, correct?
I believe so. I'm not sure of the exact wording.
Okay, let me help you with the exact wording. Turn to page 2 of Exhibit 1. The second paragraph, the second sentence from the end. I'll read it so we all have it. The report must be based upon an independent investigation by the social worker as a disinterested party. First, did I read that correctly?
Yes.
Okay. What is your understanding regarding the meaning of the word must in this sentence in the policy statement?
That it's a mandate.
Okay, so the report must be based upon an independent investigation by the social worker as a disinterested party. What's your understanding, based on your training, of what is meant by disinterested party?
I would say neutral.
Neutral. I like that. And then in reading this, now that we know that it's a mandate and that the social worker must remain neutral, says the report must be based upon an independent investigation. What does the phrase independent investigation mean in the context of this mandatory policy?
An investigation that's completed by the dependency investigator.
Correct. And when you're talking about the responsibilities in completing the report, you're talking about the obligation to be truthful, honest, accurate, complete, right?
Yes.
The obligation to disclose exculpatory information, that is information that would exonerate the other side, right?
Yes.
And that also includes the obligation to conduct an independent investigation as a disinterested third party, right?
Yes.
So at the time that you signed this jurisdiction report, the one in this case that we're talking about, you already knew that you had an affirmative obligation to include information that negates, undermines, or refutes a recommendation, position, clinical decision, or allegation in the report?
I will say yes.
Okay. Did you learn in your training that you are also required to summarize or restate information contained in the documents that you're attaching to a report?
Yes.
Okay. Did you author every part of the Juris Dispo report in this case?
I wrote the report, yes.
Okay. Did you consult with anybody?
In the course of the report, I did consult with my supervisor in regards to information for the report.
And your supervisor at that point in time was Tika Smith?
Yes.
How many times did you consult with Tika Smith while you were drafting the report?
I couldn't say.
Did she edit any portion of the report?
As a supervisor, she reviews all of our reports.
It's not my question. Listen very carefully to my question. Can I have it reread, please?
Question, did she edit any portion of the report?
I don't specifically recall edits on this particular report, but as my supervisor, she edits our reports.
Okay, when you say she edits our reports as our supervisor, what do you mean by that?
She reviews them if there's grammatical things, if there's some issue or something that she doesn't understand, she will ask for clarification.
How much time total did you spend preparing for your deposition here today?
Maybe a few hours.
A few, is that 3, 5, 7?
Somewhere between 5 and 7.
Okay. Who's Carol Berkowitz?
I don't know off the top of my head.
Did you ever speak with Dr. Carol Berkowitz when you did your independent investigation prior to drafting your jurisdiction disposition report?
I don't specifically recall.
Okay. Did you speak with Dr. Agee as part of your independent investigation?
I don't recall if I spoke with her or not.
Okay. Let's just double check that. I'm going to look at your contact notes that you brought here with us today. It's 88 pages. And it covers the time period from October 1st, 2009 to August 10th, 2010, right? Yes?
I believe those are the dates. I'm not 100% sure off the top of my head.
Well, why don't you just take a look at it and then make yourself sure. I'm going to hand you what we'll mark as exhibit number, I think, 4 to the deposition. That's your contact notes that I've just identified. Take a moment, look through them, and let me know if that is your best recollection that those are all of the contact notes for the time period listed on the first page. So, ma'am, if you would look at that exhibit number 4, do you know where in there you have listed the contacts that you made during your independent investigation?
There's just the one contact that I've entered.
That was December 22nd.
I believe so.
To your knowledge, are there any other contact notes in that exhibit 4 that show us, or that show your contacts or your efforts?
Not in the delivered service log, no.
Now, this visit that you report on December 22nd, 2009, where it says staff person, Candis Nelson, that's you, right?
Yes.
Then the purpose of the contact was to conduct a client evaluation.
Yes.
What does that mean?
I'm observing and assessing the client during the interaction.
Assessing in what sense? What do you mean by that, assessing?
I'm trying to think of how to define the word assessing.
I'm sorry?
I'm sorry, I'm trying to think of how to define the word assessing. I can't think of how to define it.
Well, I mean, as part of your job as a dependency investigator, that's one of the things you were required to do in putting together your Juris Dispo report, right, was assess and observe your client. Yes? Yes?
Yes, sorry.
Okay. So I'm wondering, when you say that part of your job was to observe and assess your client, I mean, you're the one that did this job. I don't know. I wasn't there. What was it that you were supposed to be doing by assessing client? You understand the question?
Yes.
Okay.
In this contact, I was observing the interactions and I was observing the clients and evaluating the observations that I was seeing. The observations that I was seeing.
What do you mean by evaluating? Evaluating for what?
How they were relating, their interactions with each other, any possible concerns.
Okay. Now, you reviewed these documents in preparation for your deposition here today, right?
Yes.
You reviewed specifically the entry for December 22nd, 2009?
Yes.
So how were they relating?
I would say initially they were relating as there was evidence of a bond throughout the visit. There were some times throughout the visit where some of the cues weren't picked up on in regards to the care of the child or the child's independence. But overall, there was evidence of a bond, I would say.
Okay, before we broke, you had told me that you recalled the baby in the visit on December 22nd was happy, that there was some feeding that went on, some exercises that went on, that mother and well, am I correct in that so far?
Yes.
Okay. And that the visitation went relatively, or rather that they were relating well, that there was a bond that you could see between the mother and the child, correct?
Yes, there was a bond.
How could you tell that?
And the child responding to mom and, laughing with mom and hugging on her and she was hugging on him and things like that.
So he was hugging her as well.
Yeah, when the visit started, they both appeared happy to see each other.
Okay, let me ask you first, do you recognize that document?
Yes.
Okay, what is that document that we've marked as exhibit number 5?
The jurisdiction disposition report.
And this is an official document of the Los Angeles County Department of Children and Family Services?
Yes.
Okay, and it's a document that you authored, correct?
Yes.
And at the time that you authored the document, let me ask this, did you cause this document to be filed with the Juvenile Dependency Court on or about, looks like January 4th, 2010?
Yes.
Okay. When you filed this document with the court on or about January 4th, 2010, Did you intend that the document be accepted into evidence by the judge?
Yes.
And when you filed this official document, this jurisdiction disposition report, did you also intend that the judge accept the statements in it to be true and correct?
Yes.
Did you expect the judge to take this report of yours that you authored as a true, accurate, honest, and complete statement of the then current state of the case?
Yes.
You recall attaching to this exhibit number 5 11 different attachments.
Yes, that's how many are listed here.
And that would include notices, correct?
Yes.
Medical records.
Yes.
Do you remember which medical records?
I do not remember.
Okay, we'll get to that. You also included live scan CLETS results,
Correct.
family law court documents.
Correct.
Which family law court documents?
I do not recall.
Okay, we'll get to that. You also included an upfront assessment of Miss Duval.
Correct.
A letter from a Narissa Cuynos, I don't know how to pronounce that, Cuynos.
Yes.
Email and telephone contacts.
Yes.
The child's birth, child's photo and birth certificate.
Yes.
Mother's parenting certificate and list of her readings and various classes she's been to.
Yes.
Did you ever speak with any of the child's treating physicians at the Methodist Hospital?
I don't recall.
Did you ever speak with any of the child's treating physicians?
I don't remember.
If you need to look in your Juris Dispo report to refresh your recollection, feel free to do that. Ma'am, do you have it fresh in your mind what you're looking for?
Yes. In skimming through, I'm not able to find specific statements where I actually spoke to the doctors myself
Okay.
in this report.
Do you recall sitting here today whether or not you independently spoke with any doctor ever?
I can't recall, just
Well, did you ever speak to Dr. Brousseau?
I can't specifically recall.
Do you generally recall speaking with Dr. Brousseau?
I don't know. I can't recall that.
Did you ever speak with Dr. Yim?
I can't recall.
Did you ever speak with Dr. Colo?
I can't recall.
Did you independently, as part of your independent investigation, ever speak with Dr. Gill?
I can't recall.
Do you know whether or not Dr. Gill was Ryan Duval's doctor?
I don't know.
Do you know whether Dr. Yim was Ryan Duval's doctor?
From what I can recall, I believe that Dr. Yim at some point had treated Ryan.
Okay. Did you ever report to the court in your jurisdiction disposition report that mother failed to follow the directions of Dr. Yim?
I don't know.
Okay. Did you undertake any independent investigation to find out whether or not mother failed to follow the advice and instructions of Dr. Yim?
From recollection, I can't recall whether or not I actually spoke with Dr. Yim or not, or if there was a barrier to speaking with Dr. Yim or not.
Okay, I'm going to ask you to turn your attention to page 9 of your jurisdiction report. Second paragraph. Ten lines down. Middle of the page. It says, when mother noted no concerns, failed to follow the advice of doctors, apparently resulting in her dismissal from Dr. Yim's clinic. Did I read that correctly?
Yes.
It's true, ma'am, isn't it, that you never called Dr. Yim to find out whether or not Dad's statements were in fact true?
I said I don't recall.
Okay. If you had done it, let's go back and look at your contact notes. That's exhibit number, I think, 4 to your deposition. Go ahead and take some time there and find for me the contact note for the collateral contact that you spoke with as part of your independent investigation to ascertain whether or not father's statements were true.
Well, we had already covered earlier the contact notes that I have contained in here.
Is there a contact note in there for your discussion as part of your independent investigation, your discussion with Dr. Yim?
No.
Is there a contact note in there somewhere in Exhibit 4 relating to the part of your independent investigation where you spoke with Dr. Gill?
No.
Is there a contact note in there somewhere for the portion of your independent investigation where you spoke with Dr. Brousseau?
No.
Is there a contact note in there somewhere for the portion of your independent investigation where you spoke with Dr. Boudin?
No.
Do you know who Dr. Boudin even is?
Not off of recollection.
Okay, and you reviewed these documents a couple days ago, spent 5 to 7 hours doing that, right?
Over the course of a week, yes.
Yeah. And you don't remember who Dr. Boudin is?
No, not off the top of my head.
Is there any entry in your contact notes there where you show that as part of your independent investigation you went out and spoke with Dr. Boudin?
Not in the contact notes.
Okay. Is there anything in your contact notes there where we can see that as part of your independent investigation you went out and spoke with Dr. Agee?
Not in the contact notes.
Is there anything in your contact notes that would show us whether or not as part of your independent investigation you went out and spoke with anyone?
Not in the contact notes.
Okay, what about in relation to putting together this critical document that we call the jurisdiction disposition report? Am I correct that in putting together this report, the only people that you spoke to as part of your independent investigation were Mom and Dad?
Can I look at the report?
Sure.
Okay. I would say the only interviews that are contained in here are the mother and the father's interviews under the statements.
Okay. And then if we look through this report, I mean, I see a lot of mentions about visitations. You just took those from the delivered service logs, right?
Yes, and I also spoke with Susan Pender and also with the continuing services worker on the case as well.
Who is the continuing service worker?
After Susan Pender, it was Victoria Sheely.
Okay. So let me ask you this. When you read the policy that requires you to undertake an independent investigation, what does that mean to you?
That means that I need to investigate the situation.
On your own,
Yeah,
afresh, anew, independently.
yeah,
It doesn't mean that we just go back and look at the delivered service logs and talk to the earlier social workers to get their opinion. That's not the only thing we do, right?
that's not the only thing you do, no.
Okay. In fact, what you're supposed to do is go out and verify independently, from a neutral perspective, the case. Yes?
Yes, you are to verify the information and provide a neutral assessment.
What is an upfront assessment?
It's a preliminary assessment that's done in the beginning stages of a case.
Is there any training that you've had that sort of teaches you what it is you're supposed to do with this upfront assessment, how it's supposed to be used by you, if at all?
I don't know. I don't recall.
Is the upfront assessment supposed to be attached to court reports?
I don't know.
Is the upfront assessment supposed to be used as a diagnostic tool?
The upfront assessors do not provide a diagnosis. They give a diagnostic impression in their assessment.
Are we supposed to tell the judge about the diagnostic assessments that are in the upfront assessment? The diagnostic impressions, as you put it?
I don't specifically know sitting here right now.
Never had any training on that?
I don't know. It's been a while.
Never read any policies about that?
I may have. I don't recall everything that's in all of the policies.
Well, let's see if we have something. Maybe we can refresh your recollection as to what you're supposed to be doing with those things. Actually, I already marked it. If I can get you to turn to exhibit number 1. Page number 23. Second paragraph on page 23. I'll just read it. We can read it together. If the family received upfront assessment services, indicate what agency provided services, the services provided as recommended by the upfront assessment. Do not, and this is in all bold letters, do not make reference to or attach the upfront assessment. First of all, did I read that correctly?
Yes.
Have you ever reviewed this Exhibit 1, this policy statement regarding writing the jurisdictional disposition hearing report? Have you ever reviewed it before today?
Yes.
When's the last time you reviewed it?
I don't know.
How about the structured decision-making tools? Are you supposed to do something with the structured decision-making tools in your jurisdiction disposition report?
I don't recall.
Is there an assessment that you're supposed to go through and let the court know about relative to the structured decision-making tools in your juris dispo report?
I don't know.
Did you do that in this juris dispo report? Did you let the court know about the outcomes, various outcomes of the structured decision-making tools that were utilized in this case?
Not in my report. I didn't reference SDM.
Okay. But you did reference the upfront assessment, right?
Yes.
What did you tell the court about the upfront assessment? If you need to take a moment to look through your document, you can go ahead and do that.
I indicated some of the information that was provided in the upfront assessment in regards to some of Mom's statements, as well as the areas that were noted as needing further assessment.
Here, this is interesting. Let's just start with, however, the fact remains. That's about 6 sentences down from the top of the last paragraph on page 21. And correct me if I'm wrong here, but what you're telling the court specifically is that the fact remains that while mother maintained 88% of the custody of the child's development stunted, and the child was diagnosed with failure to thrive due to environmental factors. You told the court that, right?
Yes.
This official document where you're telling him that, right?
Yes.
Okay. Then you also say, in addition, the child's regular pediatrician, Dr. Yim, discontinued services due to the mother's failure to comply with her recommendation. So you're telling the court that also in this official document, right?
Yes.
Okay. But you never talked to Dr. Yim as part of your independent investigation to find out if that was a true statement? Go ahead.
I was going to say, I never spoke with Dr. Yim. That is correct. That's what I
Okay.
testified earlier.
But ma'am, see, I'm having trouble here because isn't it part of your duties as a matter of policy to independently verify that the witnesses listed in the detention report actually said what is claimed?
Generally, yes, I would say that.
And there is no exception to that rule, correct?
I can't think of an exception off the top of my head right now.
And what is it your understanding is that you're supposed to do with witness statements according to the policy on writing the jurisdictional dispositional hearing report?
Include statements from witnesses.
Okay, and that is enter statements regarding each allegation under the headings of children, parents, legal guardian, social worker, and others, correct?
Correct.
Include verbatim statements whenever possible, correct?
Correct.
Attempt face-to-face contacts with each primary party to the petition, correct?
Correct.
What's the primary party? Who are those?
The mother and the father.
Okay. That's something you're required to do under the policy, right?
Correct.
Yes? Enter the date of the interview, the telephone number, and the location of the interview, right?
Correct.
That's something this policy requires you to do. It's not discretionary. It's something that's mandatory, right?
Correct.
Others. What does that mean, others?
People that are not children, parents, or social workers.
Like doctors, for example,
They would qualify as an other.
police, for example,
They would qualify as an other.
therapists, for example,
They would also qualify as an other.
the pediatrician, for example, the treating pediatrician. Yes?
Correct.
Okay. Make telephone contact with secondary parties listed in the detention report so that their testimony can be verified and more thoroughly understood. What does that mean?
What it says here, I understand it to mean that.
Did you do that?
I don't see it evidence that I did that in the report.
Well, you don't see evidence that you did that in the delivered service logs either, right?
Correct.
And we don't see any evidence you did that in the juris dispo report, do we?
In this report, no.
Okay, well, we know that you made other reports too, right?
Yes.
In those reports, did you tell the judge that you went out and called or spoke to or communicated in any way with Dr. Yim?
I don't know.
Okay, we can go through those later. Let's go back to exhibit number 5. That's your jurisdiction report. See what else is going on here. The next sentence after the Dr. Yim discontinued, after you tell the judge in this official document that Dr. Yim discontinued services due to the mother's failure to comply with her recommendations, you tell the judge with the concern for possible Munchausen syndrome by proxy and other personality disorders for mother, coupled with the uncertainty of the events which led to the child's significant stunted development while in the mother's care, further assessment is necessary. Did I read that correctly?
There was an extra word, but pretty
What
much
extra word?
you added in syndrome after Munchausen.
Oh, I'm sorry. That's just force of habit. Okay, let's try that again. I'll just read it and I'll try to slow down. With the concern for possible Munchausen by proxy and other personality disorders for mother, coupled with the sure uncertainty of the events which led to the child's significant stunted development while in mother's care, further assessment is necessary. First, I want to ask, what do you mean when you tell the court with the concern for possible Munchausen by proxy? What are we talking about?
In reference to the statement in the upfront assessment about further assessment being needed for that.
But here where you don't actually say that, what you say is with the concern for possible Munchausen by proxy. What are you telling the court? Are you telling the court there's a concern that mom has Munchausen by proxy?
I don't feel like I am.
What did you mean by with the concern? What concern were you talking about?
The concern that needed to be ruled out.
Do you say here to the judge, you know, we need to rule out Munchausen by proxy?
I don't say those words.
You don't. Do you tell the judge here, in fact, that there may be confusion between Munchausen by proxy and a mom who's just well educated about her child's needs? You tell the judge that.
No.
But they said that in the upfront assessment, didn't they?
I believe so.
And by that, let's just make sure we're perfectly clear in the record. Let's go to the upfront assessment. That's a document that you reviewed as part of your efforts to prepare for your testimony here today, right?
I scanned through it.
Now I'll show you what we've previously marked as exhibit number 6 to your deposition. If you can look at that for me. Is that the upfront assessment that you attached to your jurisdiction disposition report as attachment number 5?
Yes.
Okay. And your training has been that you are to summarize the contents of the documents that you attach to your detention reports, correct?
Jurisdiction disposition.
I'm sorry, yes, your juris dispo reports.
Yes.
Okay, and
When
when
they're
you,
relevant.
yeah, and when you do those summaries are to be according to the policies that you've been trained on. Those summaries are to be honest, truthful, accurate, and complete, right? Do you need the question reread? It was not a difficult question, I don't think.
Well, I would say yes, they should be accurate and they should be honest, and they should provide a summary of the information in the report.
And we don't leave out the exculpatory parts, do we? The parts that would exonerate the parent, we don't leave those out of the summary, do we? According to the policies that you've been trained on.
No.
Okay. I don't think we've shown you this yet, but let's do it now. I'll show you what we'll mark as exhibit number 7 to your deposition. It's a document titled Declaration of Candis Nelson in support of defendants Hannah, Smith, Nelson, and Shealy's motion for summary judgment. You recognize that document, ma'am?
Yes.
You turn to the page 5 there of Exhibit 7. Is that your signature?
Yes.
Says, I declare under penalty of perjury under the laws of the state of California that the foregoing is true and correct. You sign this document under penalty of perjury, ma'am?
Yes.
Okay. In your many years of training with the Los Angeles County Department of Children and Family Services, has anybody trained you as to what is meant when you sign your name under penalty of perjury?
Yes.
What's it mean according to your training?
That you're signing, indicating that the above information that you're signing to is accurate.
That it's truthful, honest, accurate, and complete, right?
I would say that it's honest and accurate, yes.
Are you supposed to exaggerate when you're signing something under penalty of perjury?
Exaggerate? No.
Are you supposed to leave critical things out when you're signing something under penalty of perjury?
I think you should include all of the pertinent information when you're signing under penalty of perjury.
Right. I want to draw your attention to paragraph number 18 here in the declaration that you've signed under penalty of perjury. And I'll just read it here for you. It says, in the training that I have received from DCFS as a DI, that's a dependency investigator, right?
Yes.
I have been trained on how to prepare jurisdictional dispositional hearing reports and last-minute information for the court reports. Did I read that correctly?
Yes.
Now, when we're talking about the training that you received on how to prepare jurisdictional dispositional hearing reports, are we talking about training in relation to exhibit number 1 that we've been talking about here today? That is the procedural guide 0300-503.10, writing the jurisdictional dispositional hearing report. Is that what we're talking about? Yes?
Yes. This
Okay.
information has been provided to me as part of my training.
Okay. And that includes training regarding how you're supposed to independently investigate the allegations that come before you that you're dealing with in your jurisdiction disposition report, right?
Yes.
And that includes the requirement under the policy that you make telephone contact with secondary parties listed in the detention report so that their testimony can be verified and more thoroughly understood, correct? Right?
Yes.
Okay. And under the same policy, you've been trained that we do not make reference to or attach the upfront assessment to the jurisdictional report, correct?
In certain parts of the policy, yes, it does reference that you're not supposed to attach the upfront assessment.
And you signed under penalty of perjury in this declaration that you've had all that training, right? Am I right, ma'am?
I signed that I have been trained to complete reports.
Well, it says, yeah, I have been trained on how to prepare jurisdictional disposition hearing reports, right?
Yes.
That's under penalty of perjury, right?
Yes.
And it was in relation, your training was in relation to this policy number 0300-503.10, right? Yes?
That was, I reviewed this policy was provided to us as part of our training.
So going back to the concept that you've been trained on about how you're supposed to accurately and truthfully summarize the records that you attach to your jurisdictional report, did you do that here with regard to the upfront assessment? Did you truthfully, honestly, and accurately summarize the upfront assessment that you attached to your jurisdiction disposition report?
I did not provide a complete summary of the entire document, but I provided information that was referenced to needing additional assessment.
Let me try that question again. Maybe it was complex. Let's sort of go through it together. Did you truthfully, honestly, and accurately summarize the contents of the upfront assessment?
It's the same answer. I provided the information from the upfront assessment in regards to the information that was referenced as needing more evaluation.
Was there any exculpatory information, as you've been trained that on that term, was there any exculpatory information contained in the upfront assessment based on your training? Just based on the training that you swore under penalty of perjury in that declaration, Exhibit 7? Based on the training that you had there, that you were talking about there, did you disclose the exculpatory information that's contained in the upfront assessment?
Well, the entire document was attached for the court's review, and in referencing the upfront assessment, I referenced the information that the assessor noted needed further evaluation.
Did you accurately summarize it, or did you just cherry pick pieces of it? You know what cherry pick means, don't you?
Can you describe it?
Yeah, where you just pick out the pieces that you want the court to look at. Is that what you did here with the upfront assessment? Pick out the pieces that you want the court to look at?
No.
Okay, so somewhere in your report, we should find the exculpatory summaries too, right?
I included the information from the upfront assessment that it was recommended for further assessment.
Did you tell the judge in your truthful, honest, and accurate summary of the upfront assessment that at this time the disorder may have been confused with a mother who is medically knowledgeable and well informed about her son's diagnosis of sensory integration disorder? Did you tell the judge that in your report summary?
I provided the entire document as an attachment, and I referenced the information that
Let's look at
indicated
page
further
21.
assessment.
Let's look at page 21 of your jurisdiction report. Okay, bottom paragraph, page 21. First, you tell the judge, Dr. Yim discontinued services due to mother's failure to comply with her recommendations, right? You see where we're at?
Yes.
Okay, you're telling the judge that Dr. Yim said that, right? That she discontinued services due to the mother's failure to comply with her recommendations? Yeah?
That is the statement that's there.
But then you go on to tell us here at page 21 of your Juris Dispo report that with the concern for possible Munchausen by proxy and other personality disorders, who had a concern about Munchausen by proxy, if possible Munchausen by proxy? Whose concern was that?
The upfront assessment indicated that further assessment was needed on that.
Hold on. I know what it says. What you're telling the judge is that there was a concern for possible Munchausen by proxy, right?
The statement says with the concern for possible Munchausen by proxy, and continues on from there.
Okay. And other personality disorders for mother, right?
That's what it says.
Okay. And then you couple that concern with some other material, right? Am I correct that we have two different things going on here? One is your concern about Munchausen by proxy, and the other is the sure uncertainty of events which led to the child's significant stunted development, right? What do you mean by coupled with? See where it says coupled with?
Mm-hmm.
Yes?
Yes.
What did you mean by that?
In conjunction with.
So your concern about Munchausen by proxy in conjunction with what?
I never stated I had a specific concern.
Okay, what does it mean here where we say with the concern for possible Munchausen by proxy and other personality disorders? What are we talking about?
That there was noted concern for those things to be assessed.
But where does it say there is noted concern for those to be assessed?
Well, that's what you're asking me what it means. That's what I'm saying to you, is that's,
Well, maybe I'm reading this differently than you are, because what I see is with concern number 1 and our uncertainty about the child's stunted development number 2, while he was in mother's care, we need further assessment. Am I reading it right? So we have 2 different concerns, we put them together, and now we need further assessment, right? It's a basic logic issue.
what it says is that there's concern for Munchausen by proxy and other personality disorders, and that there's uncertainty about the events that led to the child's stunted development, and that further assessment is needed.
Yeah. Okay. So again, let's look at page 21 of your Juris Dispo report. Do you tell the court anywhere on page 21, your summary of the upfront assessment, at this time the disorder may have been confused with a mother who is medically knowledgeable and well informed about her son's diagnosis of sensory integration disorder? You tell the judge that in the body of your 23-page jurisdiction disposition report. Take your time if you need to read it.
I'm not seeing that information in here.
Yeah, it's not in there. I've reviewed the report too. I appreciate you looking through it though and telling me that you don't see it either. I'm correct on that, right?
Yeah, I don't see it in here.
Okay. And also missing from your summary of the report is the statement that the full criteria needed to meet factitious disorder by proxy was not evident through the assessment. You don't tell that to the judge in your summary of this report either, do you?
I don't see it in the report.
Okay. Let me ask you this. You read the upfront assessment at some point in time, right?
Yes.
Okay. When you read it, who first came up with the idea that mother potentially was Munchausen by proxy? Whose idea was that?
I don't know whose idea that was.
Did you see in the report where mother claimed that father's family was the ones accusing her of Munchausen by proxy?
In the jurisdiction disposition report?
We're talking about the upfront assessment, ma'am.
In the upfront assessment, if that statement is in there? Is that what you're asking me?
I'm asking you, did you read in the upfront assessment that it was mother's concern that the father's family was accusing her of Munchausen by proxy?
There was a statement that indicates that mother claims that the father's family is making the claims of Munchausen by proxy.
Right. That's right. It was mother that was making that claim. Right?
That is a statement in the upfront assessment that is what mother reportedly informed the upfront assessor.
And then what they say in the upfront assessment that you did not report to the court in your summary that was supposed to be truthful, honest, accurate, and complete was that this disorder must be distinguished from a mental disorder in the individual and distinguished from abuse that is not motivated by the goal of indirectly assuming the sick role. At this time, the disorder may have been confused with a mother who is medically knowledgeable and well informed about her son's diagnosis of sensory integration disorder. The full criteria needed to meet factitious disorder by proxy was not evident through the assessment. That's the part that you left out, right?
There's a lot of information in this assessment that did not make it into the report.
Ma'am, am I
That's a complete
correct that
report.
you left out the statement that I just read?
The statement that you read is not in the report.
Okay. All right. According to your understanding, is Munchausen syndrome by proxy a mental disorder?
I really haven't studied it enough to know off the top of my head whether or not it fits into any particular category.
But you do know enough about it to know that you're not qualified to diagnose it, right?
Yes.
What is a last minute information?
Additional information provided to the court for the court hearings.
Is that a form of court report?
Yes, it's a report to the court.
And as with all other reports that you make to the court, are last minute informations also official documents?
Yes.
And when you file them with the court, do you intend that the court accept them into evidence?
Yes.
And when you file them with the court, do you also intend that the court take your statements in those last minute informations to be true?
Yes.
I'm going to show you what we will mark as, number 8. Exhibit number 8. It's a last minute information dated January 22nd, 2010. If you look down at the bottom of the page, last sentence reads, "Mother's disregard for the doctor's orders as evidenced by her continuing to offer low-calorie snacks to Ryan." Did I read that correctly so far? You with me? Do I need to read it again?
No, I was just trying to find it in the paragraph.
Okay, it's at
Within the
it's,
sentence.
It's the second line up from the very bottom. Says mother's disregard. Are you with me?
Yes.
Mother's disregard for the doctor's orders as evidenced by her continuing to offer low-calorie snacks to Ryan. Did I read that correctly?
Yes.
Which doctor were you talking about? Was it Dr. Yim?
I'm not exactly sure exactly which doctor it is. I don't know all the doctors' names.
Was it a doctor that you spoke to on the telephone?
I don't recall speaking of whether or not I spoke to the doctors or not, so,
But we know there's none in your delivered service logs, right?
yes.
Okay. What is sensory integration disorder?
I don't know off the top of my head.
Did you review the regional center records on this child?
I believe those may have been reviewed back when the report was completed.
Okay. And in your Juris Dispo report, did you disclose to the court in your summary of the regional center records that the regional center had preliminarily diagnosed the child with sensory integration disorder?
Can I review the report?
Sure. Spend all the time you need.
It indicates that per regional center, Ryan suffers from some sensory issues.
Sensory issues? What sensory issues? If I'm the judge reading this summary of yours that's supposed to be truthful, honest, accurate, and complete, what sort of sensory issues did the regional center assess Ryan as having? Well, you wrote the report, right?
Yes,
And you reviewed those records when you wrote the report, right?
I believe so.
So tell me, what sort of sensory issues was Ryan having?
I don't know off the top of my head.
Okay, ma'am, off the record, you went through the regional center report, the occupational therapy developmental evaluation that was done by the Eastern Los Angeles Regional Center, correct?
Yeah.
And in there, what you found was that Ryan displays significant difficulties with sensory processing, which is interfering with his motor planning, ability to sequence movements, and coordination, which has impacted his floor mobility and ability to achieve the required preambulation skills for the emergence of independent ambulation, correct?
Yes.
Do you tell the judge that somewhere in your jurisdiction report that Ryan displays significant difficulties with sensory processing, which is interfering with his motor planning, ability to sequence movements, and coordination, which has impacted his floor mobility and ability to achieve the required preambulation skills for the emergence of independent ambulation?
I did not provide that sentence that I can find in this report.
Okay. All right, moving on to I'm going to show you what we'll mark as exhibit number 9 to your deposition. It's a document titled Information for Court Officer for the hearing dated March 8th, 2010. Do you recognize that report?
Yes.
That's an official document that you filed with the court.
Yes.
When you filed the document, you intended that the court accept it into evidence,
Yes.
and you also intended that the court take the comments you make in this report as true. Yes?
Yes.
Turning to the second page, that's your signature there, right?
Bless you. Yes.
Thanks.
And that Tika Smith, you recognize the signature there as being her signature?
Yes.
Okay, looking at the first paragraph, 4 sentences in, or 4 lines in, where it begins, however, per CSW Victoria Sheely. Do you see that?
Yes.
And it goes on to say, mother continues to be overprotective and overbearing to the child. Yes?
Yes, I see that.
You wrote that?
Yes, it's in this report. Yes.
You didn't see that yourself.
No.
You were just reporting what Victoria Sheely told you.
Yes.
You didn't go and monitor some more visits in March on your own to see if that was in fact true, did you?
No, I did not monitor any further visits.
Looking at the last sentence of exhibit number 9, it says here, CSW Sheely indicated that Ryan seems to express more free will and autonomy with his father and appears to develop passivity with his mother, believed to be in response to mother's overbearing and rigid parenting techniques. That's not something you yourself witnessed. That's what Miss Sheely told you?
This sentence is referring to what Ms. Sheely told me.
Right. I'll show you what we'll mark as exhibit number 10 to your deposition. It's a last-minute information dated April 12th, 2010. If you turn to the second page of exhibit 10, that's your signature there, right?
Yes.
And when this exhibit 10, this is an official document
Yes.
that you caused to be filed with the court on or about April 12th, 2010.
Yes.
When you filed it, you intended that the court accept it into evidence,
Yes.
and you intended that the court accept the statements contained in this exhibit 10 as true, correct?
Yes.
Okay. 1, 2, 3, 4. 4 lines down from the top, it reads, and this is over towards the right-hand side of the page, it reads, Dr. Lott reported that he was unaware that this matter was court involved. Did I read that correctly?
Yes.
Did you speak with Dr. Lott? Was he one of those guys that you called on the phone to verify that what was being attributed to him was true and to further understand what he was saying?
I don't recall.
Okay, you don't recall calling Dr. Lott.
I don't recall whether or not I called him.
Going on to exhibit number 11, I'm showing you what we will mark as exhibit number 11. It's another last minute information dated June 21st, 2010. Okay, if you turn to page 2, is that your signature at the bottom of the page?
Yes.
Was this an official document?
Yes.
Was it one that you caused to be filed with the court?
Yes.
And when you caused it to be filed with the court, did you intend that the court accept it into evidence?
Yes.
And did you also intend that the court accept it as true?
Yes.
Okay. And then at the bottom of this exhibit number 11, you write, however, actually it says, Ryan continues to reject food offered by mother. Do you see that? It's like the fourth line up from the bottom.
Is it on
The first page.
first page?
Page 1. Fourth line up from the bottom, over on the right-hand side. Tell me when you get there. Ryan also continues. Do you see it?
Yes.
So you write, Ryan also continues to reject food offered by mother. However, CSW Sheely noted that foods that Ryan rejects during the visits, he is observed to eat and enjoy during CSW's visits with Ryan when Ryan is at home with his father. That's what you wrote there, right?
That's what it says.
Now, you never personally observed this statement here in June 2010, did you?
Not in June, no.
Okay, this was all stuff that Miss Sheely was reporting to you, right?
These were things that were reported by Ms. Sheely, correct?
Did you do anything at all in June 2010 to independently verify what Miss Sheely was telling you?
In regard to the visitation?
Mm-hmm.
No, I did not myself observe any visits in June.
Okay. Now, you didn't meet and speak with Mother in June either, did you?
I don't recall whether or not I spoke with Mother in June or not.
Well, in looking at your delivered service logs, there's no entry in the contact notes for a conversation that you had with Mother in June, is there?
No.
No, there's not. I'm
No.
correct.
No, there's not an entry.
Okay. Was it Miss Sheely that reported to you that Mother continues to work on trying to find explanations for Ryan's developmental issues which exonerate her? Was it Miss Sheely that told you that?
Where is that listed?
Page 2.
I can't say for certain that this information is coming from Ms. Sheely or whether it's coming from any conversations or interactions or information I received from Mom directly.
But we know that it's not in your contact notes, right?
Yes, correct.
And we also know you don't say here on June some date, I met with Mom and she told me XYZ. You don't say that, do you?
No.
And according to the policies that you've been trained on, when you meet with somebody on a date and you speak with them about a particular subject, you're supposed to say, I met with this person on X date and spoke with them about this, right?
The policy does indicate listing dates and names of the people that you spoke with.
Right. And those are the same policies that you declare under penalty of perjury in Exhibit 7, which is your declaration in support of summary judgment that you've been trained on. You said you've been trained on those policies, yes?
Correct.
Okay. Just didn't follow. Am I right about that? You didn't follow those policies?
I did not list any dates or the names of Mother if those conversations did occur.
Policy says that you're supposed to, right?
Policy says to indicate the names and dates of people that you speak with.
And you didn't do that.
I do not see it listed here.
Okay, so we don't know for sure whether you had a conversation with mom or not, because you didn't tell us here, right? And you don't remember as you sit here today.
Yeah, I don't recall, so I can't say for certainty.
This is really an odd statement, this next one. It says, as the child was in mother's care for the large majority of the time as an infant, with father having minimal visits, the neglect in his parenting resulting in development delays and failure to thrive must be attributed to mother as the child's primary caregiver. You see that there?
Yes, I do see that.
You wrote that?
I wrote that.
Was that your conclusion?
That is an assessment.
That is your conclusion?
I'm not 100% sure that it's 100% attributed to only my conclusion as opposed to in conjunction with other statements.
Well, who wrote that?
I wrote that.
Did your supervisor, Ms. Smith, tell you to write that?
No.
I see she didn't sign this particular report, right?
Yes.
Is there some reason that she didn't sign this report?
This was just providing additional information. It wasn't changing any recommendations or anything like that.
So it's your testimony here today that the statement that the child's failure to thrive must be attributed to mother. That's just another statement, it's not new information. What are you trying to tell the court here, where you say that the child's failure to thrive must be attributed to mother as the primary caregiver? What are you trying to tell the court?
That the neglect in his parenting resulting in developmental delays, so if there's neglect in his parenting, his parenting and it's resulting in failure to thrive, if mother is the primary custodian and primary caretaker, then she would be the person that would have provided that care.
So it must be her fault. No other explanation.
I didn't say that.
Well, you're saying it must be attributed to mother as the primary caregiver.
Saying it needs to be linked to the fact that she's the primary caregiver, and if there were some deficits in the parenting that led to the failure to thrive, if she's the primary caregiver, then yes, they need to be linked to her.
What were the deficits that led to the failure to thrive?
While the reports from Failure to Thrive Clinic indicate environmental factors, there were also notations of him not getting a sufficient amount of nutrition in his diet. So things like that were attributed to his failure to thrive.
That was all mother's fault.
I didn't say it was all mother's fault.
Well, you say must be attributed to mother. What does that mean?
That it is linked to her as the primary caregiver.
And attributed means that she's the one doing it, right? When you attribute something, it means she's the one doing it, right? What does attribute mean to you?
As the caregiver, that there must be some role that she is playing in these things that are coming up.
That was your theory.
That was my assessment.
All right. We'll show you what we will mark as exhibit number 12 to your deposition. It's an email from a Michelle Hochstein dated Wednesday, July 7th, 2010. Okay, Do you recognize this email?
It looks familiar.
Okay, do you see about 1, 2, 3, 4, 5, 6 lines down where it says tracking?
Yes.
It says recipient, Nelson Candis. See that?
Yes.
And it says read July 7th, 2010, 2:16 p.m.
Yes.
Does that refresh your recollection as to when you first received and read this email?
Yes.
Did you call her?
I don't know if I spoke with her on the phone or emailed her.
Do you remember communicating with her in some way on or about July 7th, 2010?
I don't recall what day we made contact.
Do you recall what the principal complaint was against you?
I don't know specifically what the principal complaint was against me.
Well, let me ask this first. You understood that somebody was complaining about you, right? You were the subject of an investigation.
Yes.
Okay, so you've never had a parent complain that you were dishonest about them in a court report, either by omission or by making a false statement. You've never had that complaint?
I'm sure parents have complained that they didn't agree with the information in reports.
Okay. You ever had a parent complain that you failed to disclose exculpatory evidence to the court in your reports?
I don't recall that ever being a complaint.
Do you ever recall a parent complaining that you attributed mental conditions to them that were not diagnosed?
That may have been something that was stated as part of this.
When is the next court report that you filed in Ms. Duval's case?
After the July hearing? I mean, after the July email?
Yeah.
I don't recall. I don't know.
See if we can refresh your recollection. I'm going to show you what we'll mark as exhibit number 13 to your deposition. And it's a document titled Last Minute Information for the Court, hearing date July 26, 2010. You recognize that report?
Yes.
Your signature's there at the bottom?
Yes.
Okay, do you tell the court anywhere in there that you are the subject of a civil rights investigation?
No.
Have you ever heard of a social worker being removed from a case on the basis of bias?
I have heard of that.
You have. And in fact, according to the policies that you've sworn you were trained on, you are to be the neutral, disinterested eyes and ears of the court in your reporting, right?
Correct.
Okay. And if there is an issue of bias, then there could be a question about your neutrality, that is your disinterestedness, right?
Can you clarify the question?
Okay. If you are being investigated formally in relation to a parent's complaint that you discriminated against them in some way, is it your understanding that that does not impact in any way your role as a neutral, disinterested reporter for the court?
I feel like even with this investigation, I was still able to be unbiased in making assessments for the family.
That's in your assessment, in your mind, right?
That's my assessment of it, that I was still able to make unbiased
And
statements to the court and recommendations for the family.
But you never disclosed the information to the court so that the court could assess whether or not there was an appearance of impropriety there, did you?
I did not inform court about this civil rights investigation.
Okay. I'll show you what we'll mark as exhibit number 14 to your deposition. It is a Letter dated July 31st, 2010, titled Letter of Determination CDSS/CRB, case number 1059121, addressed to Ms. Nelson. You recognize that letter, ma'am?
It looks familiar.
Okay, let's look at it together. It says, Dear Ms. Nelson, thank you for your cooperation in the recent investigation conducted by the DCFS Civil Rights Unit. A thorough investigation revealed a violation of client Rafalina Duval's civil rights on the basis of disability. A separate letter will be forthcoming advising you of corrective measures to be taken by DCFS. First, did I read that correctly?
That was read correctly.
Okay. Do you remember reading it on or about July 31st, 2010?
I can't state what date I read it, but I do remember seeing this letter.
Who was the charging party?
I would assume it to be the person filing the complaint, Ms. Duval.
Okay, and they're telling you here in this letter, do not contact Ms. Duval, right?
Do not contact the charging party or conduct yourself in any manner that could be interpreted as retaliation.
Okay. Now, at this point in time, July 31st, 2010, you were still her DI, right?
I believe so.
Okay. Now that you know that you have been Now that you know that a thorough investigation revealed a violation of Rafalina Duval's civil rights on the basis of disability, did you go to the court in a last-minute information and say, hey, look, Judge, I've been accused, I've been investigated, and it's been found that there was a violation? Did you do that? Did you let the court know?
I did not inform the court of this investigation.
And you didn't inform the court of the outcome either, correct?
That's correct.